The Deep Docket, your insider briefing on AI and patents. I'm your host, Bastian, and these are the top news this week. Did OpenAI just ban lawyers from using ChatGPT? The answer is no, but the real story is far more important. Also, Perplexity AI makes a direct play for the patent search market. And a special announcement from my own AI-powered patent drafting toolkit. This week, everyone in my LinkedIn feed was freaking out about OpenAI's new terms of use. You may have heard the headlines claiming OpenAI just banned ChatGPT from giving legal advice. This was sparked by a policy update which prohibits using ChatGPT for, and I'm quoting, the provision of tailored advice that requires a license, such as legal or medical advice, without appropriate involvement by a licensed professional. So let's clear the noise. This is not a new ban. This isn't about a change in function. It's about a change in liability. OpenAI knows legal professionals are using the tool, and this clause officially shifts the liability from them, OpenAI, to the appropriately involved licensed professional. So what does this mean for your practice as a patent attorney? Well, this is your explicit note that you are the human in the loop and you bear 100% of the responsibility. It doesn't mean stop using ChatGPT, but it does mean you must review every single word. Second, a new player has entered the prior art search game. Perplexity AI, the company known for its citation-focused answer engine, has launched Perplexity Patents. Now, this isn't just another ChatGPT for patents, but what makes it interesting are two core features. First, it uses semantic search, not just keyword search. So, for example, it understands that a query for, let's say, fitness trackers also should find patents for health monitoring wearables. Second, it seems to search non-patent literature at the same time, pulling in things like academic papers, technical blogs, and even GitHub code repositories. That looks like it could be a huge step toward automating a true state-of-the-art analysis. So my bet is that on the one hand, this is not going to replace your professional search tool or search provider tomorrow, but for R&D teams and for patent managers doing initial landscaping or novelty checks, this could be a powerful new tool. For patent attorneys, an interesting use case might be for drafting, for example, the background section of a patent application. So using this to get a quick overview of the prior art could be a massive time saver. And finally, a special announcement I'm incredibly excited to share. For the past several months, I've been developing my own first AI tool called Claim Drafter. It is officially launching to the public on November 18th. So this isn't another one-click patent drafting robot. It's a professional-grade assistant for practitioners. I've designed it to be kind of a second set of eyes to help you iterate, refine, and stress test your patent claims using a structured thinking process that is based on the EPO's problem-solution approach. If you want to get on the launch list, you can sign up at powerclaim.io. That's powerclaim.io. So, what's the unifying thread this week? The theme is specialization. The OpenAI story shows the clear limits and liabilities of a generalist AI hitting the wall of professional responsibility. It highlights why a general purpose tool isn't the final answer in our field. And that's why the other two stories are the future. We are seeing the rise of specialist tools, Perplexity Patents for semantic search, and tools like my Claim Drafter for the high-stakes, very specific tasks in a patent drafting workflow. So the future of AI in patents isn't chat, it is precision. That's all for the Deep Docket this week. For more, subscribe to this podcast. I'm your host, Bastian. Talk to you next week.
Game over.